You're listening to the Multifamily Marketwatch for Washington State. Apartment owners who need to know, trust HFO, the leading source for multifamily industry news around the state, from Puget Sound to the Tri-Cities.
I'm Greg Frick, partner at HFO Investment Real Estate. Today we have back with us Brad Krause of Warner Allen, one of the preeminent landlord-tenant lawyers here in the Northwest. Thanks for coming back to talk to us today, Brad. I was going to think we're going to highlight a little bit about the state of Washington and talk a little bit about, as we've talked about before off camera, landlord-tenant law, the regulations kind of were a little tougher to deal with the last couple of years, but, maybe that's coming back a little bit. I don't want to say coming to center, but getting a little bit easier, and maybe highlight what's changed in 23 and compare it a little bit to the state of Oregon as well.
Thanks for having me. The state of Washington landlord-tenant realm is getting a little bit more close to normalcy as, some pre-COVID folks that remember the pre-COVID times. As everybody who's dealt with evictions and non-payment matters in Washington probably remembers, through all of COVID, we had the eviction resolution pilot program. And then we also had repayment plan obligations that were required. The eviction resolution pilot program obligations, those sunset as of July 1. So that sort of situation and that obligation has now gone away. So that's very beneficial because that was a real drag on the process. It often added weeks, sometimes in the early goings, months to the process. The repayment plan obligations have subsided with respect to any rents that are due and owing from May of this year forward. So if, for example, your non-payment notice only includes, June and July's rent, if you were going to serve that notice today, all you would be required to serve is a non-payment notice. So we're back to just that, thankfully.
So if you're dealing with somebody that has a non-payment issue from April, do you recommend that they just kind of not deal with that and just file for, stuff from May 1st and on? Does that make it easier?
Well, it does in the sense that if you include amounts from April, let's say you have a tenant that hasn't paid rent for April, May, June, and July. The moment that you include the April rent in that notice, you are still required to offer a reasonable repayment plan for that.
I got you. Okay.
But if you remove the April from that and you just include May, June, and July in the non-payment notice, then there is no repayment plan obligation that's required there. So it puts you in a little bit of a stronger position.
Gotcha. Okay. And that's a big change for Washington. I mean, like you said, during COVID, it was very difficult up there in dealing with some of these issues.
It is. And, the repayment plan, as everybody probably remembers, the obligation, the maximum that you could require a tenant to pay would be 1/3 of the monthly rent. So for folks that had pretty high balances that accumulated through COVID, those payment plans would stretch on for a really long time. And odds are you would never see the back part of that or even all of that repaid. So it really put a strain on landlords in terms of the rent that they were sort of forced to sit on. It's unfortunate that they had to deal with that because it did put a lot of strain, especially on the smaller landlords. But nowadays we're sort of back to normal a little bit. We've got some additional changes to Washington landlord law as it relates to some aspects of eviction actions, and I can touch on those in a second, but also to some security deposit and accounting obligations that have changed pretty recently as well.
And again, on some of these changes, this is statewide in the state of Washington. This is not in Clark County or Vancouver or Spokane. It's statewide that these are going through.
Yep, statewide. So the changes to the eviction resolution pilot program, that's sunset by statute. So that statute was 59-18-660, and that expressly sunset as of July 1. And the repayment plan obligations, that's just embedded into the statute in terms of kind of what I had indicated, the interplay there.
Gotcha. Okay. And so let's talk about kind of what's in place now and what's kind of changed, and give people some highlights on that.
So we had two pretty big recent changes that were enacted in I think it was late May, and they became effective as of July 23rd. So the two bills that I'm talking about, Senate Bill 5197 and HB 1074. And 5197, that deals with some technical changes to evictions and the like. And then 1074 is the changes to accounting and security deposit obligations for the landlord.
Is it more restrictive in terms of how you do security deposits? Have you briefed your clients on what they need to do with this?
Yeah, so anybody that has property on both sides of the river, particularly in Portland, remembers sort of the fair obligations, the Portland Fair Ordinance, in terms of documenting the condition of the property before you can withhold monies from the deposit for things like damages. A lot of people remember the obligation to document the fixtures, appliances, condition of the carpet, all of those sorts of things. That obligation in similar aspects now exists in Washington with HB 1074. So HB 1074, basically it embedded a definition of what normal wear and tear is, except they don't call it normal wear and tear. They call it wear resulting from ordinary use of the premises. So it's normal wear and tear. That's what we all know it as. So that has a statutory definition in Washington now. With respect to the prohibitions on withholding for damages, landlords were required to do a checklist or a sort of move-in,
move-out checklist.
Condition report. That was in there. It's a bit more stringent now in that by statute, you're not allowed to, and it expressly says that you cannot withhold money from the deposit if you do not document the condition of the property. So it's an express limitation on that, much like Portland had put in place once FAIR went into effect in the Portland city limits.
But I know in Portland there was the issue where you had to find, what the original cost was of the appliance, and we had issues with people that had bought properties and didn't buy the dishwasher, and then having to do a depreciation schedule. Is it that restrictive, or is it just more of a notification period and having to document?
Not that restrictive, thankfully, because that became a little bit ridiculous. The language just basically requires that the landlord, reasonably document the condition of the premises. Things like depreciation value in terms of carpets and things like that. Those sorts of things landlords generally do take into account. They don't need to be told to do that. They don't need to be told that a 20-year-old carpet, if a tenant moves out, you're not going to be charging them for the full replacement of that carpet. It's got some miles to it. Right. But it basically just requires that landlords reasonably document the condition of the property in the checklist. There's forms available for that. What I have been telling my clients is, look, pictures still tell 1,000 words. They tell the story. So if you're documenting the condition of the premises, obviously that checklist, that move-in, move-out report is going to be good for you. But pictures don't hurt. Pictures tell everything. The requirements of that, I think, is met there in terms of documentation. So.
Okay. So are you thinking it's going to be the rest of the year? It'll be a little bit easier than, across the river in Washington, and as opposed to, some of the, I won't say heartache, but it was just a little bit more difficult based on what was coming out of Olympia.
It was challenging. I would say as things go, folks are going to start seeing a bit more normalcy, a bit more of an easier process as it relates to unlawful detainer cases. The right to counsel is still there, so we work with attorneys all the time in terms of eviction cases. The process has become a lot easier because the amount of forms that landlords need to deal with and the amount of rules and restrictions that they have gone away. The big sort of thing that I am still seeing and that I want folks to be aware of is in Washington, the CARES Act issue and with respect to the Federal CARES Act is a hot button topic up in Washington. It's if your property is a covered property under the CARES Act, then it's going to be a 30-day pay or vacate notice as opposed to the standard 14-day pay or vacate notice. And when we have eviction cases, that's really the first line of defense that I see tenants' attorneys look at. They look at whether the property is a covered property.
And what's a covered property, again, just to highlight for people that don't remember? What's a covered property in the CARES Act?
If you've got a federally backed mortgage, so like a Fannie or Freddie mortgage, that's going to hit you there. If the tenant that you have, or if you're subject to any sort of federal housing programs like LIHTC, your tenant's a Section 8 tenant, it's going to make you a covered property as well.
So as in your line of work, you've got to ask them what the debt is on the property before you can decide what the line of, what action you take in terms of on the operation side.
I typically rely on my clients a lot. We've coached them up quite a bit to know what their property is, whether it's a covered property. But when I'm drafting notices for my clients, I will typically ask them right out of the chute, is this a covered property or not? And a lot of times I'll either get an answer or I'll get what's a covered property.
Right. Interesting. Okay. Well, thank you for taking the time to kind of give us a quick update. I'm sure we'll be talking again. It seems like we're doing this on almost a quarterly basis, trying to get updates. I'm hoping that we slow down a little bit on all the changes and we can all kind of get our breath and, like you said, get back to some normalcy and how we do this process. So thank you again for enlightening our audience.
Our entire office specializes in multifamily real estate, making HFO the largest multifamily brokerage in the Pacific Northwest. Your success is our passion. Build your legacy with HFO. Call 503-241-5541 or visit our website at hfore.com for more information. HFO is an affiliate of the Global Real Estate Advisor Network.